Hello, how are you? Welcome back to my channel. Happy Friday, 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 Friday. And to my American friends, I hope you have the best long weekend. The sun is finally shining a little bit here. It has been dark in Toronto for almost a week, 7 days. But today the rain has been slowly disappearing and the sun is slowly coming out. Thank gosh. But happy Friday. We have so much to get into, a lot of motions. We're just going to be reading some court dockets. So there are 3 in particular. Blake Lively has filed a letter to the judge. We'll get into that, as well as Jennifer Abel. The Wayfarer parties have responded to Stephanie motherfucking Jones. I've already read them, so we're going to go over just the most relevant information from there because a lot of this stuff is kind of repeated from their original claims. And first, we're just going to start with a little bit of hot news, things that are in the headlines today, and then we'll get to your comments. So if you're ready, I'm ready. Buckle in, grab your emotional lip gloss, and you're in frame with Mandy Magnan. Very interesting article came out today in the Daily Mail, and they like to use lots of headlines like everyone, all the buzzwords and the catchphrases to get you. And they say that they have a source from Taylor Swift who has spoken out. So it is kind of worth a read, even though the headline is like, Taylor Swift, I wish I'd never met Blake. New humiliation for Lively as singer outs the glaring red flag she missed during their 10-year friendship. They go into like the history of the entire It Ends With Us drama, but then it does say down below, it's perhaps little surprise then that Swift, godmother to Lively's 3 daughters, is said to be relieved. Their decade-long bond is now over. Right now, if Taylor had one wish, it would be that she never met Blake, an insider told Daily Mail. Although there have been good times during their relationship, the issue now concerning the BALDONI case has outweighed them. When Taylor looks back at their friendship, she realizes it wasn't worth all the stress Blake put her through. She can now see all the red flags that should have been a warning to her. Taylor had to tone Blake down time and time again because she was always wanting to be the leader of the pack. Taylor's relieved the relationship is over. She put up with Blake's antics for too long because she's a loyal friend. It took the It Ends With Us drama to finally get her to pull the trigger on it. It is understood that a dutiful Kelsey is following suit in cutting off Lively and Reynolds. Taylor and Travis are disgusted with Blake and Ryan and how they tried to use Taylor in their fight against Justin Baldoni. Our insider said, they're vowing their break from the acting couple is permanent. Ouch. This week, Blake Lively took to her Instagram in order to promote her new products for Blake Brown. There is new mist coming out. Why that's so strange is because she's literally saying that Blake Brown and Betty Boo's, her companies, suffered damage due to the smear campaign, but is launching new products. Is very strange. But I just want to talk quickly about some statements that she put out, because as we're going to get into in the court docket, she likes to say that Justin Baldoni and the Wayfarer people are lying. But liar, liar, pants on fire, that's you, Blake Lively. Blake Lively's a busy woman these days. Amid her legal battle with the It Ends With Us co-star Justin Baldoni, the actress is growing her beauty brand, Blake Brown, which launched a trio of hair and body mists on Monday. This was a response to our community going, please make fragrance. The Another Simple Favor star told People, we never planned on doing hair and body fragrances. Oh no, you just did it because the people were asking you to. Now, I've shown this document before, and all is fair in love and war, right? But it just goes to show, like, it's just kind of hilarious. And I said before and stated in a video before that I think that it wasn't just her hair care line, but Blake Brown needed to succeed at their launch in order to branch out and really take over the cosmetic and hair and everything to do with the beauty, right? They really wanted to expand. And this is Blake Brown's own trademark from her company. And underneath where it says, what is Blake Brown for? You can see all of the stuff, hair preparations and treatments, shampoos, hair mousse, etc., etc., etc. But if you look at the bottom as well, it does say face oils, body emulsions, aftershave emulsions, etc., perfumery and fragrances, cologne, perfume, soaps and gels, bath gels, shower gels, essential oils, and aromatic extracts. So you had this in the work beforehand. Don't come out and just tell us that the people asked you to do it. So all of a sudden, like that, you had this body mists. You just did this just out of nowhere. Come on, these were already pre-planned, and you cannot fool me to think that you just made these up in a whim and it wasn't already going to be your next line. After, your shampoo and conditioner. I don't even know what the other Blake Brown stuff is that's out right now. But stop lying, girl. And we're driving right into the court letters and motions. Okay, we're getting right into it because there's a lot to go over. This was filed by Blake Lively. Yet again, another letter filed in the courts by Blake Lively. And what I find kind of funny is that this letter motion for leave is to file a reply. So they've submitted a letter in order to ask to file a letter no more than 2 pages, but the letter that they submitted was 9 pages. So I just think, I don't know, it just kind of makes me laugh. Like, those kind of things I just think are kind of silly. And as we know, the Judge Lyman has said before, for every motion put in, you get 1 reply, right? So they filed a letter, the Lively people filed a letter to compel. The Wayfarer people answered that, and now Lively wants to answer that answer to her motion to compel. And it's about getting the discovery from the investigation that Wayfarer initiated in January of 2025 after Lively, at the end of December, alleged sexual harassment. Filed May 23rd, 2025 by Ezra A. Hudson, lawyer for Blake Lively. Dear Judge Lehman, on behalf of Blake Lively, we write pursuant to Rules 1C and 4C of Your Honor's individual practices to respectfully request leave of this court to file a letter of no more than 2 pages in reply to Wayfarer Studios LLC and It Ends With Us Movie LLC, together the Wayfarer, opposition to Miss Lively's motion to compel. Less than 24 hours after Wayfarer filed its opposition on May 22, 2025, Miss Lively received correspondence from Wayfarer's investigators, Rains Feldman Littrell LLP, and Adam Investigations Counsel, the investigators, directly undermining positions asserted by the Wayfarer in its opposition with regard to production of and application of the attorney-client privilege to materials responsive to Ms. Lively's 4th set of requests for productions, the investigation materials. Ms. Lively's anticipated reply will address such inconsistencies and the material impact of the same on Ms. Lively's motion to compel. Accordingly, Ms. Lively respectfully requests the court grant leave for her to file a 2-page letter brief in reply to the Wayfarer's opposition, a copy of which is attached hereto as Exhibit 1. Can you do a 2-pager? Are you able to do that? Because your people like to just send in 1,000-page documents. You know what I'm saying? And then we go into Exhibit 1, which is her 2-page letter to the judge. So, she already did it. You already submitted the letter, so it's just funny that you're asking, oh, am I able to submit this? I've attached it. Here it is. But this is the letter. Dear Judge Lyman, so they're just saying, in their opposition to Ms. Lively's motion to compel, Wayfarer Studios and It Ends With Us Movie represented to the court that the materials sought are outside their possession, that they take no position regarding application of the attorney-client privilege to those materials, and that the proper channel to obtain documents and witness recordings concerning its investigation into Ms. Lively's sexual harassment and retaliation claims is by subpoena directly from the investigators. Yesterday afternoon, less than 24 hours later, Rains Feldman Littrell LLP and Adam Investigations Counsel, the investigators, took the opposite position. In an email, the investigators reiterated their refusal to produce the investigation materials, invoking Wayfarer's attorney-client privilege, and encouraged Wayfarer to resolve the issue with Miss Lively directly. In other words, Wayfarer and its investigators are each refusing to produce relevant and responsive materials while pointing at the other to do so. They have created a perfect trap to prevent Miss Lively from obtaining information essential to her claims and defenses. Not Miss Lively being trapped again. Gosh, she's trapped a lot. In that same correspondence, the investigators provided to Wayfarer and Miss Lively a purported privilege log, various documents with various third-party witness and or their counsel, as the grounds for withholding the investigators' cite Wayfarer's attorney-client privilege, Wayfarer's work product and or investigators' work product without providing any further information. The investigators' log, however, does not include a single date or identify any individual that sent, received, or created the withheld documents and communications. It is therefore wholly insufficient to enable Miss Lively or this court to evaluate whether the attorney-client privilege or other protections may apply. More importantly, the investigator log, such that it is, plainly undermines Wayfarer's position that it does not possess the investigation materials. Wayfarer clearly has some documents referenced on the investigator's log which appear to be directed to or provided by it to the investigators, or is withholding them for a reason it has not made clear. If it is because of privilege, it has not provided a privilege log. Wayfarer has not even attempted to effectively assert a privilege as to the investigation materials, and its privilege log does nothing to establish that such a privilege exists as to any of the documents that exist. On the contrary, Wayfarer said in opposition that it takes no position on the investigator's assertion of Wayfarer's alleged privilege to the documents. Because Wayfarer takes no position on the privilege and failed to set forth any preliminary facts establishing that a single investigation document is privileged, while the investigators in turn also failed to do the same, they have given the court no basis to find that any of the existing documents are privileged. These files are plainly within Wayfarer's control and are fundamentally not privileged, and Wayfarer has failed to establish otherwise. Accordingly, Miss Lively respectfully requests that the requested documents, including all witness recordings, be produced. And look at all her lawyers. Oh my gosh. So Blake is pretty much saying that everything that Brian Freeman said is a lie. Everything the investigators so far said they're doing to collude with Brian Freeman and the Wayfarer parties, and everyone is just out to get Blake Lively. Even the independent investigators who have replied, many replies in which we can get into, said that they are an independent investigation firm and they are just here to get to the truth and investigate the claims that were made at the end of December, and they started doing their investigation at the beginning of January. So everyone's lying, everyone's colluding together to attack and trap and destroy Blake Lively's career and reputation. Now, some of this could or could not be true. Does Brian Freeman and the Wayfarer parties have some of the investigation so far? Maybe. Do they want to give it to Blake Lively because it is attorney-client privilege? Yes, possibly. Is the investigation finished? Probably not. I mean, why would Brian Freeman come out and say that the investigation is still underway? It just all seems a little bit strange. I think the judge should get to the bottom of whether or not the independent investigators are still, number one, investigating, and number two, of their findings. But they did, in Exhibit A, attach those emails that were sent, and then we can read those. So this is the reply email. So the first email that was sent is from Blake Lively, and it is to Lauren, and they're just talking about their discussions and understanding the discussions. And then she says, as I mentioned on the call, with regard to the first 2 points, both Raines, Feldman, and Adams investigations were required at the time of responding to provide a privilege log. Please confirm by the end of the day that pursuant to this rule, Rains, Feldman, and Adam Investigation Counsel will provide a privilege log for all responsive documents being withheld in short order. To the extent that you are withholding communications with third-party individuals, those not employed by Wayfarer, please also provide by the end of day a basis for doing so. As to the third point, we have been unable to find legal authority holding or even suggesting that a subpoena to an investigator in this context is either improper or unlawful. To the extent that you are aware of such authority, please provide that by end of the day, or alternatively, please confirm this objection will be withdrawn. And that email was sent on May 13th, like Brian Freeman has said. And then on May 22nd, on Thursday, they responded saying, Stephanie, while we believe that our objections provide sufficient information for all parties to assess the privileged nature of the documents, in response to your request, we have prepared the attached privilege log. We invite counsel for both parties to confer, inasmuch as the documents are subject to privilege held by Wayfarer, and we hope this log will aid in that conferral. To the extent your May 13th email is attempting to narrow the scope of the investigator's objections, we do not agree and we are relying on the objections previously served. And then they do show the log here that they were able to get, and it does show that they were, there is 6 logs all done, but whether or not these are finished or not and completed is the question. If they're not completed and Wayfarer doesn't have all of it to go through first, they're not going to send it to Blake Lively's team. I don't think they're necessarily withholding information. I just think that they're waiting for it to be done, and then they would like to conduct their own analysis of the findings before even turning them over. So I don't know. She's just out here calling everyone a liar, liar, pants on fire. Everyone's colluding. This independent investigation team, why would they be withholding information just to get Blake? I don't know. We'll see. It'll be interesting. I think Judge Lehman probably is happy that there is a long weekend and a holiday coming up. So take a breath, people. That's probably what he's thinking. Probably, because it's just every day. My gosh. I'll be honest, I'm not really too sure what to think about all of that because I don't know. What is going on here? No, I'm just kidding. I really don't know. There's no facts yet. We don't know. I'm trying to take Brian Freeman's word for it that he doesn't have the full investigation yet, that he hasn't been able to go through it yet. So asking for it and filing a subpoena and then a motion to compel and all of this stuff to the investigators when they're not even done their job yet. I think at some point Judge Lehman does need to step in and, enough is enough and lay some more ground rules or have a serious talking to these parties, because it doesn't seem like they are conferring together to get the discovery, which is what he had said before running to the courts. Try to work it out among yourselves, and it doesn't seem like they are playing nice with each other, and it does seem like the Lively parties continually are running to the court, like it was the sanctions, the motions to compel, and now this, I don't know. I think the long weekend will be good for everyone to take a breath, gather, focus on your next move, and yeah, we'll see what happens. You know what? I didn't even put my necklace on today because I just finished filming 2 commercial auditions. This is a busy day so far, and I'm just kind of, it's just been a busy day. So anyway, that makes me feel a bit better. Now, when it comes to yesterday, that was kind of a big day when it came to a bunch of news. Of course, I spilled some tea from a reliable source about Brian Freeman getting all of the text messages and more than what he needed. And then it was late yesterday afternoon that it actually came out, and the Wayfarer people made a statement saying that they withdrew the subpoena on Taylor Swift because they got more than what they wanted, and Taylor Swift kind of, worked with them and played with them. Now, these text messages that they have, it's not just like an easy, oh, now we have all of the text messages from Taylor that prove this. Like, how do we go forward? What do we do? It's not black and white. And I think it's going to be very interesting how they decide to use whatever information they got and the substance of that information and what even those text messages say. So I think it's going to be interesting because Brian Freeman did come out in a statement yesterday and say that they have evidence that Blake Lively's lawyers did in fact try to coerce Taylor Swift into her support for Blake Lively and threaten to release private text messages. So if they have those communications, people are in trouble. But how are they going to use them and submit the information that they have? That is where I think things are going to get really interesting and messy between both parties, because the information might be juicy and hot tea and they might have it, but does it have to do with this case? And if it does, how? And if it's witness tampering or spoliation, et cetera, how does that play out with, you know, the courts and then the jury as well? So it's going to get quite messy. And on that note too, I just want to say something super bizarre happened to me today. It was very strange, so I'm just going to share it here and let y'all know. It really made me take pause and kind of jolted me a little bit. I had a couple of supporters today reach out to me on Instagram and ask if they could use little clips from my video, which I always appreciate when people reach out and ask first. And I love these people. So of course I was like, yeah, of course. I've never denied anyone using any of my stuff, really. I just like it when people ask first, right? And so somebody posted on their Instagram a little clip of the tea that I spilt yesterday about my source reaching out to me. And this source, by the way, has led me down rabbit holes, have shared videos with me. We go on Easter egg hunts. You know what I mean? They've never steered me in the wrong direction. So I do trust their source. And I trust that what they told me was accurate. And it's actually been proven now that Wayfarer has made a statement saying as much, that they got more than what they needed and what they wanted, and that's why they pulled the subpoena for Taylor Swift. Whether that's true or not, I mean, I was relayed the information early yesterday morning, late yesterday that statement came out. Whether that's all fabricated or not, we won't know yet. But what happened is after they posted that onto their Instagram, a very large creator following this case, I mean huge, the biggest, right? Woman following this case wrote under her post, "I don't believe her." And when I saw that, I was like, oh, a little gutted at first, but then I just wrote wowzers. And I just didn't know where that was coming from, because I've never questioned their sources or where they get information, and I support their channel a lot. So I was just a little bit shocked by that. And this isn't the first time I've seen creators go try to start drama or just attack other creators. And I just thought that was very weird. And then moments later, their comment was deleted. And I don't know, it just kind of put an ucky taste in my mouth, because I'm just doing the best that I can with the information that I have and relaying it here to the people watching, and I wouldn't just boldly come out and say a lie if I didn't think the source was reliable. And in that video, I do say it's alleged. It's coming from a source that I believe to be true and who is in of the people who would have this information. I can't say more than that. But for someone with such a massive, I mean, one of the biggest following here, who does investigative journalism, and herself has been under attack. I just thought that was, it was a little strange, and honestly, it was a little heartbreaking to just read that and to see the lack of support by someone whom I admired. And I don't know, like, we shouldn't be, discrediting or attacking each other. We're all doing the work. And that's what I came to, I took some time and I was thinking, it's not going to stop me from still being here and showing up and relaying the information the best that I can do it. I just thought that was kind of a low blow and really sad. Really, really sad, because I've seen a lot of creators before kind of fighting each other, battling each other, tearing each other down, and we're taking enough heat from B613 and other people trying to suppress us and make us stop and attack us that we don't need to be doing that with each other. And believe me or don't believe me, that is totally up to you. I can't tell you what to believe, nor would I want to. I mean, critically think for yourself, and that's fine. Honestly, that's what I want people to do, especially when I'm reading court documents and sharing the news and stuff. Like, you don't have to have my opinion. You can form your own and believe whatever you want to believe, and whether that's me or not, that's cool. Don't believe me, but then to publicly go on someone else's Instagram and state that, I thought was very sad and a little tacky, if I'm being honest, and it didn't do anything. It didn't come from a place of light or hope or constructive criticism or anything. It was just such a bold statement and then later retracted. And yeah, I don't have any room for that. When I see things I don't like or I don't believe or I don't follow, I scroll past, and then the things that I do, I look into and I research. So anyway, that happened today and this morning, and it was a little bit strange. But anyway, let's get into Stephanie motherfucking Jones. Come to the front, girl. Okay, we're going to go over Jennifer Abel's response and then the Wayfarer party's response. And they're both relatively shorter than most, about 30 pages each. But again, I've highlighted the most relevant parts. And let's talk about it. If we just rewind a little bit back in time, back it up. Stephanie Jones filed an amended complaint in order to get dismissed. She filed a motion to get dismissed. Wayfarer answered back, and then she filed an amended complaint to get dismissed. And now this is Wayfarer's response. Stephanie Jones pretty much took the route that she did nothing wrong. Abel went rogue. She showed text messages between Nathan and Abel that were super cherry-picked and out of context. Like, one of them was like, yeah, we're going to war. And then Stephanie Jones wrote underneath that, like, yeah, this proves that they were talking about me, da-da-da-da. But they could have been talking about anything and anybody, especially that day there was news coming out. I think that was the day that Ryan Reynolds and Snake Lively tried to get Justin Baldoni and Jamie Heath to file that big apology, to make that big apology. So there was a lot going on. So what she was saying, like what her evidence was and like what she put in there compared to what she was saying, I felt was like very opposite, if that makes sense. Like, it didn't really match up for me. But then when it came to the Jennifer Abel stuff, then she was saying, and then also with the Jennifer Abel stuff, she was just saying like she did it on her own, she went rogue, da-da-da-da-da. She didn't do anything wrong with the phone because she was following a lawful subpoena, and et cetera, et cetera, et cetera. And then with Wayfarer, she's saying that Wayfarer breached their contract. She doesn't owe them anything because, again, it was a lawful subpoena. That's kind of like to, glaze over it. But there is a whole video going over those motions that if you want to check out, I will put that first one in the description for you. So this is Jennifer Abel's memorandum of law in opposition to plaintiff's motion to dismiss her amended counterclaims. Jennifer Abel's amended counterclaims arise from the theft of her private data by her former employer, JonesWorks, and its principal, Stephanie Jones, together JonesWorks. Having pillaged Abel's personal iCloud and email accounts, JonesWorks has undertaken a malicious campaign to villainize and humiliate her and destroy her professional reputation. Mission accomplished. Abel now asserts claim for violation of multiple data privacy statutes as well as common laws for invasion of privacy, infliction of emotional distress, and fraud. Its fiend outrage notwithstanding, JonesWorks' argument for dismissal are weak and convoluted. As set forth below, Abel amply satisfies her pleading burden. As for Abel's data privacy claims, JonesWorks violated the Stored Communications Act SCA by accessing, oh my god, every time I say accessing, I say the wrong word. By accessing Abel's text messages and emails from cloud-based servers owned by Apple and Google without authorization and the Federal Wiretap Act FAW by intercepting her messages in real time through iCloud after Abel's termination and the seizures of her phone. JonesWorks also violated California Penal Code through its willful misuse of Abel's private data. JonesWorks' jurisdictional argument carries no weight because its misconduct occurred in California and was directed toward a California citizen. Although JonesWorks invokes the New York choice of law provision in Abel's employment agreement, it neglects to consider the limited scope of the provision, which does not extend to Abel's tort claims. Abel also readily shows sufficiently outrageous conduct to sustain her intentional infliction of emotional distress claims and breach of a duty underpinning her negligent infliction of emotional distress claim. Abel's conversion claim based on JonesWorks' theft of her longtime personal phone number likewise passes muster. Final, Abel pleads fraud with the requisite, particularly alleging the who, what, when, and where required rule under 9B of the Federal Rules of Civil Procedure. The court should deny JonesWorks' motion as to Abel's 2nd through 10th claims for relief. Abel's counterclaims satisfied the applicable pleading standards and warrant adjudication on the merits. However, should the court find any aspect of Abel's pleading insufficient, Abel respectfully requests leave to amend her counterclaims to cure any perceived deficiencies consistent with the liberal standard for amendment under Federal Rule of Civil Procedure 15A. Then they go into a lot of the factual background, which we're not going to talk about that much because we should know if you know. But there are a few things that were kind of new. For the entirety of her tenure, Abel largely managed JonesWorks' work for Wayfarers Studios and Justin Baldoni. Behind closed doors, however, JonesWorks was a troubled work environment led by an erratic and mercurial leader. Jones's worst excesses were largely hidden from a view due to draconian non-disclosure agreements, Jones's threats, and a climate of fear pervading Jones's past and present clients and employees. In or around May 2024, the chaos burst into public view as news outlets began to report that JonesWorks was hemorrhaging clients, and a website called Stephanie Jones Leaks went live disclosing a litany of disturbing allegations about Jones's behavior and business practices. At around the same time, Jones learned that the Business Insider was working for an unflattering story about her. The torrent of negative publicity sent Jones into a tailspin. This conduct included, among other things, creating fake social accounts to these individuals, planting negative stories about them, and falsifying allegations of misconduct. Sound familiar? Stephanie motherfucking Jones already did that to people who went against her. Allegedly, she was asking Jennifer Abel to do these things while she was working there, and she would set up fake social media accounts, Stephanie Jones, of individuals talking to media about her or any clients that left her and would, or she didn't like, or even I think there was an ex-employee she did this to. And she would plant negative stories about them and falsify allegations of misconduct. Who else right now is falsifying allegations of misconduct after getting Jennifer Abel's text messages from Stephanie Jones? We continue. On July 10th, 2024, Abel notified Jonesworks that she intended to resign as of August 23rd, 2024. Jones took the news poorly. Still, Abel was committed to departing on amicable terms. In her final week, Abel arranged the release of her phone number and personal data upon her departure. That was critically important because upon joining Jonesworks, Abel was issued a company-owned iPhone to serve as her primary communication device and encouraged to transfer her personal phone number to the Jonesworks corporate phone plan. As a result, the iPhone became a hybrid device, serving as the central point for both her personal and professional digital communications and data. Throughout her employment, Jonesworks did not provide Abel with any written policies, guidelines, or instructions regarding the use of company-owned devices for personal purposes. That's going to be interesting because, Stephanie Jones was claiming, well, it was a work phone. But if there was no written policies or guidelines on how to use that work phone, and allegedly they didn't even have like an HR department or any kind of like leadership to go to. So that's also going to be very interesting. There were no documented restrictions or advisories concerning the integration of personal accounts, the storage of personal data, or the expectation of privacy in relation to personal information stored on company devices. In the absence of any such policies or warnings, Abel had no reason to believe that her personal data would be subject to access or review by Jonesworks, and she should use the device for both work and personal matters. Jonesworks assured Abel multiple times, including during her final week, that it had no problem releasing her phone number and personal data. Abel did not believe. Then they go into the day that, they trapped. Oh my gosh. Trapped. They brought, Jennifer Abel's last day or her last week, and then a couple of days before she was actually supposed to have her last day, she walked in, she got escorted into this room. They searched all of her stuff. They made her sign a bunch of stuff. She said that she felt like she couldn't leave, and Stephanie Jones was like, she could have left anytime, no big deal. But then they reiterate the fact again that Abel did not believe that she was free to leave. And also warning that Jonesworks would have grounds to sue if she refused to sign the documents or give over her phone and laptop. A search of Abel's laptop turned up nothing of note. Abel was told her passcode was needed to facilitate the release of her phone number. She did not consent to a search of the device. Because she was ambushed, she had no opportunity to wipe the device or log out of her personal accounts. Intimidated and shell-shocked by the experience and desperate to leave, Abel asked for confirmation that Jonesworks would release her phone number, which she received, and then complied, surrendering the device and disclosing her passcode to the Jonesworks chief of staff. She was then frog-marched out of the building. Jonesworks had usurped her phone number and cut off her access to critical accounts protected by two-factor authentication. And then we know that she went to Verizon and was there for hours while Stephanie Jones and the chief of staff was telling her, we're going to release your phone number. She was there for almost 4 hours, and they were telling her, we're going to release it, and then just ghosted. The very day, Jonesworks shared Abel's private communications with Blake Lively's publicist, Leslie Sloan. Abel also learned that Jones had been sharing her private text messages with the entire office, mocking and disparaging her. Very shortly thereafter, Jones disseminated Abel's stolen communications directly to Sloan, Lively, and her husband, Ryan Reynolds. Abel's text messages revealed that Abel and others in the Wayfarer Studios circle held Lively in deep disdain. The reasons why are well documented. What they do not reveal in any sort of wrongdoing of the kind alleged by Lively. Regardless, Jones knew full well how Abel's communications would be used by an embattled Lively and her team. Enlisting the help of the New York Times, Lively and her team commissioned a hit on the Wayfarer parties, including Abel. To create a veneer of legitimacy surrounding their possession of Abel's private text messages, on September 27, 2024, the Lively parties initiated a sham lawsuit in the New York State Supreme Court. The sham lawsuit was filed on behalf of Van Zandt Inc., a corporate entity associated with Lively, and named only Doe defendants. That same day, JonesWorks warned a departing employee not to work for Abel because her business would not be around much longer. Once the lawsuit was filed, the Lively parties used it to issue a subpoena on JonesWorks for the private communications extracted from Abel's iCloud and email accounts. By strategically naming only Doe's instead of the proper defendants, Lively avoided having to give them notice of the subpoena. Neither Lively nor JonesWorks notified Abel that her private communications and personal data was being turned over to the Lively parties. Working in concert, JonesWorks and the Lively parties were able to cover up how Jones obtained the information. Say it louder. They literally did cover up how they gained the information. All they kept saying was lawful subpoena. No one ever admitted to how they actually did it. JonesWorks retained access to Abel's iCloud until Abel changed her password in January of 2025. From August 21st, 2024 through then, JonesWorks was monitoring and intercepting in real time Abel's text messages through her iCloud account. On December 26th, 2024, JonesWorks sued Abel, Wayfarer, Baldoni, and Melissa Nathan in the New York Supreme Court. The action was removed to the Southern District of New York, where Abel brought counterclaims against JonesWorks. In her operative amended counterclaims, Abel asserts claims for 1. Violation of the Computer Fraud and Abuse Act, 2. Violation of the Stored Communications Act, 3. Violation of the Federal Wiretap Act, 4. Violation of the California Penal Code, 5. Invasion of privacy, 6. False light, 7. Conversion, 8. Intentional infliction of emotional distress, 9. Negligent infliction of emotional distress, and 10. Promissory fraud. To survive a motion to dismiss under Rule 12b of the Federal Rules of Civil Procedure, a plaintiff must state enough facts to state a claim to relief that is plausible on its face. A complaint will be dismissed where the allegations in a complaint, however true, could not raise a claim of entitlement to relief. Abel's data privacy claims are adequately pleaded. Abel asserts statutory claims arising from JonesWorks' unauthorized access, copying, and dissemination of Abel's private communications and data loaned from Abel's confiscated cell phone. Federal and state law prohibits the unauthorized accessing, copying, and disseminating an individual's private text messages and emails without consent. The fact that JonesWorks owned the iPhone did not vest JonesWorks had the right to extract Abel's private data from her non-JonesWorks cloud account without consent, which Abel never gave. Abel's claims are well supported by fact and law are more than sufficient to survive dismissal. As a preliminary matter, JonesWorks' motion relies heavily on a long out-of-district case, Sunbelt Rentals, Inc. v. versus Victor, to manufacture a false impression that Abel's claims are legally deficient. Sunbelt Rentals is readily distinguishable. Therefore, the plaintiff failed to plead the detailed allegations present here, and the employer's access resulted from the employer's carelessness, not the employer's willful conduct. Moreover, Sunbelt Rentals is inconsistent with established law and has been criticized for its cursory treatment of evolving privacy issues. Abel states a claim under the Stored Communication Act. The Stored Communication Act provides a civil remedy against anyone who intentionally accesses without authorization a facility through which an electronic communication service is provided, and therefore obtains, alters, or prevents authorized access to a wire or electronic communication while it is in electronic storage. JonesWorks argues that the data stored on personal devices such as Abel's iPhone does not satisfy the requirement for an SCA violation. However, Abel alleges that JonesWorks accessed her communications stored on cloud-based servers owned by Apple and Google. Courts have consistently held that such cloud-based systems are the type of facilities the SCA generally protects. Abel's allegations that JonesWorks accessed. It's just one word, accessed. Abel's allegations that JonesWorks accessed her cloud-based accounts without authorization are sufficient to state a claim under the SCA. Abel states a claim under the Federal Wiretap Act. The FAW, Federal Wiretap Act, prohibits the intentional interception, disclosure, or use of wire, oral, or electronic communications except as authorized. Jonesworks argues that Abel's federal wiretapping claim fails because she does not plead simultaneous interception of communications. Jonesworks is simply wrong. The amended counterclaim explicitly states that after Abel left Jonesworks and after Jonesworks seized her phone, Jonesworks accessed her iCloud account and used it to monitor her text messages in real time, contemporaneously with her transmission. Where multiple devices are logged into the same iCloud account, both receive messages in real time. This is precisely the type of interception the FWA prohibits. Jonesworks remained logged into Abel's iCloud account and received her messages as they were sent and received by Abel after she regained access to her account. These allegations are sufficient to state a claim under the FWA. Abel states a claim under the California Penal Code Section 502. Jonesworks relies on outdated law. Jonesworks first argues that because it used the passcode coerced from Abel, it did not circumvent technical or code-based barriers and therefore did not violate the penal code. However, Jonesworks' argument relies on stale case law requiring circumvention of technical barriers. Then they state a bunch of laws. Abel alleges that Jonesworks obtained and copied data from her iCloud and email accounts without permission, causing her harm. This is all that is required to state a claim under the Penal Code 502. It is hard to take seriously Jonesworks' contention that it has no notice of Abel's accusations or that her allegations of harm were insufficient. Right. I remember that in Stephanie Jones's thing, she was saying that she was stating all of the medical things that have to happen to someone in order for the harm to be done, and that she was saying that Jennifer Abel didn't fall under those things. Jonesworks' jurisdictional argument fails. Jonesworks next argues that there is no nexus between their unauthorized access and California. However, for a Section 502 claim, courts apply the purposeful direction or effects test, which is satisfied where the defendant's intentional acts are aimed at the forum state and cause harm there. Abel is a California resident based in Los Angeles who suffered harm in California. Jonesworks seized Abel's iPhone in California and upon seizure accessed its data in California. Thus, the acts occurred in whole or in part in California. California has a strong interest in protecting its residents from tortious injury. Abel's tort claims are adequately pleaded. California law applies to Abel's tort claims. Jonesworks is trying to get it out of California and I believe into New York. Jonesworks contends that New York law, not California law, governs Abel's counterclaims and that as a result, Abel's fifth and sixth causes of action must be dismissed because New York does not recognize these claims. Jonesworks bases this argument on a New York choice of law provision in Abel's 2021 employment agreement, which states the agreement and the performance of the parties' obligation hereunder will be governed by and construed in accordance with the laws of the state of New York without giving effect to any choice of law principles. The key issues are whether this provision is valid and whether it applies to all of Abel's counterclaims. A federal court sitting in diversity applies the forum state's choice of law rule to determine both the validity and scope of contractual choice of law provision. Under New York law, such provision is enforceable if the chosen law has sufficient contacts with the transaction and there is no fraud or violation of public policy. Although Abel lived and worked primarily in California, the provision may be valid given Jonesworks' New York domicile. However, the scope of the provision is limited. Under New York law, a contractual choice of law clause applies only to contract-based claims unless it expressly covers the entire relationship between the parties. The provision here is limited to the agreement and the performance of the parties' obligations hereunder and does not reference the broader relationships between the parties. Such a narrow provision does not extend to tort or other non-contractual claims. Thus, New York law applies only to contractual claims. Because the New York choice of law provision does not reach Abel's tort claims, the court must conduct a separate choice of law analysis for those claims, applying New York's choice of law rules as the forum state. First step is to determine whether New York and California law conflict. An actual conflict exists where the law would lead to different outcomes. Here, there is a direct conflict. California recognizes claims for false light and invasion of privacy, while New York does not. Where such a conflict exists, New York law applies the law of the state with the most significant relationship to each claim, a doctrine known as dépassage. Dépassage. For tort claims, this is generally the plaintiff's domicile where the injury occurred. Here, California's interest is far greater. Abel, the plaintiff, is domiciled in California. The tortious conduct occurred largely in California, and Abel suffered harm and incurred economic losses in California. Abel's invasion of privacy claims are adequately pleaded. Abel states a claim for intrusion upon seclusion and invasion of privacy under the California Constitution. To state a claim for intrusion upon seclusion under the California common law, a plaintiff must allege that 1. The defendant intentionally intruded into a place, conversation, or matter as to which the plaintiff has a reasonable expectation of privacy, and 2. The intrusion occurred in a manner highly offensive to a reasonable person. Similarly, a claim for invasion of privacy under the California Constitution requires a showing that 1. The plaintiff possesses a legally protected privacy interest, 2. Maintained a reasonable expectation of privacy, and 3. The intrusion is so serious as to constitute an egregious breach of the social norms. It was highly offensive. Courts often analyze these claims together, focusing on whether there was a reasonable expectation of privacy and whether the intrusion was highly offensive. The allegations against Jonesworks go well beyond mere access to her work emails on a company-owned device. Abel alleges that Jonesworks, under false pretenses and without her consent, accessed and obtained all of her private data and personal information, including her text messages, personal emails, photos, notes, browsing history, and sensitive medical and financial information. Furthermore, Abel alleges that Jonesworks not only accessed this information, but also shared her private communications with others in the office to mock and disparage her, and continued to monitor her communications even after her departure from the company. Abel also alleges that Jonesworks had no internal policies governing its employees' use of electronic devices or reserving the right to monitor such usage. These allegations, if true, support the existence of a reasonable expectation of privacy in the personal data and communications at issue. The fact that Abel was logged into her personal accounts on a company device does not, as a matter of law, eliminate her privacy interest in those accounts or her contents. Courts have recognized that employees may retain privacy interests in personal information stored on or accessible from employer-owned devices, particularly when the employer's conduct is egregious or exceeds reasonable business-related boundaries. The alleged conduct by Jonesworks accessing, reading, and disseminating Abel's private communications and personal data for the purpose of humiliation and harm could be found by a reasonable jury to be highly offensive. The scope and nature of the intrusion, including the sharing of private messages with others and the continued monitoring of Abel's communications after her employment ended, support the claim that the intrusion was egregious and violated societal norms regarding privacy. Abel states a claim for false light. Under California law, false light is a species of invasion of privacy based on publicity that places a plaintiff before the public in a false light that would be highly offensive to a reasonable person, and where the defendant knew or acted in reckless disregard to a falsity of the publicized matter and the false light in which the plaintiff would be placed. Abel alleges that Jonesworks and related parties manipulated, altered, and selectively disclosed her private communications to create a misleading and damaging impression of Abel's involvement in a supposed smear campaign, which Jonesworks knew was false. In other words, Jonesworks acted with actual malice. Abel alleges she was harmed by being portrayed in a false light. Abel states a claim for conversion. To establish a claim for conversion, a plaintiff must demonstrate 1. Ownership or a right to possess the property in question, 2, that the defendant wrongfully exercised dominion over the property, interfering with the plaintiff's rights, and 3, resulting damages. This standard is recognized under both New York and California law. Historically, courts were hesitant to recognize conversion claims for intangible property such as phone numbers because conversion was traditionally limited to tangible physical objects. However, the law has evolved to reflect the realities of the digital age. Both New York and California courts now recognize that intangible property such as electronic records, domain names, and even websites can be a subject of a conversion claim. When it comes to phone numbers, courts have increasingly recognized that they can constitute a unique and valuable property interest, especially when the phone number is closely associated with an individual and has acquired value through use and publication. Several cases have found that phone numbers may be subject to conversion. Then they list all of the cases. Abel alleges a possessory interest into her long personal phone number, which was deeply intertwined with their personal and professional lives. She further alleges that JonesWorks wrongfully exercised control over the number by refusing to release it, thereby interfering with her rights and causing her harm. Abel's emotional distress claims are adequately pleaded. Abel states a claim for intentional infliction of emotional distress. To state a claim for intentional infliction of emotional distress, IIED, a plaintiff must allege 1. Extreme and outrageous conduct by the defendant undertaken with the intent to cause or reckless disregard for the probability of causing emotional distress. 2. Severe or extreme emotional distress suffered by the plaintiff. And 3. Casual connection between the defendant's conduct and the plaintiff's distress. To the standard for outrageousness in demanding requiring conduct so extreme as to exceed all bounds of that usually tolerated in a civilized community. However, courts recognize that a deliberate and malicious campaign of harassment or intimidate or abuse of a position of power can satisfy this standard. Abel's IIED claim is based on a sustained malicious campaign by JonesWorks, her former employer, to destroy her reputation and personal life. JonesWorks abused its position of power to obtain Abel's private communications, emails, and personal photos under false pretenses. It then disseminated this sensitive information throughout its office, mocking and disparaging Abel, and published her private messages, including those with her fiancé, family, and friends, without her consent. Abel was rendered powerless as JonesWorks had seized her private information and cut off her access to critical accounts, including bank accounts, utilities, and insurance. JonesWorks also retained access to Abel's iCloud account for months, monitoring her communications with clients, loved ones, and counsel, and intentionally leaked her private messages, upending her life. Abel continues to live in fear, knowing JonesWorks still possesses her sensitive data. These allegations go far beyond mere dissatisfaction with management style and describe conduct that is sufficiently extreme and outrageous to state a claim for IIED. Abel also adequately alleges severe emotional distress. She describes experiencing panic and despair upon learning her private information had been usurped and her accounts cut off. She asserts that her life has been turned upside down and that she lives in fear of what is to come, given the hostile actor's possession of her personal data. Wow. The hostile actor's possession of her personal data being Blake Lively. She asserts that her life has been turned upside down and that she lives in fear of what is to come, given the hostile actor's possession of her personal data. Who knows what Blake can do with that if it's true that she was already trying to extort Taylor Swift and threatened to use Taylor Swift's text messages, who was supposed to be the godmother of her children and her best friend. What will she do with Jennifer Abel's information? Awful. These allegations are more than sufficient to meet the pleading standard. The law does not require a specific set of symptoms. Any highly unpleasant mental reaction such as fright, shame, humiliation, or worry is sufficient. Abel states a claim for negligent infliction of emotional distress. A claim for a negligent infliction of emotional distress, NIED, requires a breach of a legally cognizable duty of care resulting in foreseeable emotional harm. Abel's NIED claim arises from Jones Works' failure to safeguard her personal information. As her employer and custodian of her data, Jones Works owed Abel a duty to exercise reasonable care in protecting her sensitive information. Jones Works breached this duty by disclosing Abel's private information to third parties on multiple occasions, including in response to a facially overbroad subpoenas without notifying Abel or objecting to the requests. As a direct result, Abel's private information was leaked, leading to a daily stream of death threats, and abuse, and causing her to feel fear for her safety. Abel states a claim for promissory fraud. To state a claim for promissory fraud, a plaintiff must allege 1. Misrepresentation, 2. Knowledge of its falsity, 3. Intent to defraud, 4. Justifiable reliance, and 5. Resulting damages. Promissory fraud arises when a party makes a promise without any intention of performing it, which constitutes an actionable misrepresentation. Abel's pleading meets these requirements. She alleges when the fraudulent statements were made on August 21st, 2024, where the statements were made at Jones Works LA office, who the statements were made by Jones Works' chief of staff, Gordon Duran, and its attorney from Frankfurt, Cornet, Klein, and Sels. What? The content of misrepresentation was a promise that if Abel surrendered her Jones Works issue iPhone and provided her passcode, Jones Works would release her personal phone number and her private data and accounts. Abel further alleges that she reasonably relied on this promise and that Jones Works never intended to perform. Instead, Jones Works' true intent was to induce Abel to surrender her phone and passcode so it could access, copy, and disseminate her private information and retain her phone number, all to cause chaos in her life. At Verizon, Jones Works assured both Abel and Verizon that it was in the process of releasing the phone number and asked them to wait. Abel never heard from Jones Works again and left Verizon 4 hours later in panic and despair. As a result, Abel suffered significant harm. Finally, while Jones Works may have owned the physical phone, it did not own the personal information and data stored on it. Abel would not have surrendered the phone without first securing her data if not for Jones Works' false promise. In sum, Abel's allegations are pleaded with the particularly required by Rule 9b and sufficiently state a claim for promissory fraud. Conclusion. For the ongoing reasons, the court should deny Jones Works' motion in its entirety. If the court is inclined to grant the motion to any extent, Abel respectfully requests to leave and re-plead. And then you got the two lawyers there working for them. I mean, law firms, many lawyers, but law firms. So there you have it. That's the first one from Jennifer Abel. I mean, I think they have grounds for it. I don't think Stephanie Jones at all should be dismissed, but again, I'm biased and I'm also not a lawyer or a judge, so who knows. But I think they did, all of her points, they came back, bam, 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 bam. And I know it's a lot to go over and it's a little bit dry and can be a little bit boring, but I think instead of just reading fast headlines and tabloids and relying on, other people's word for it, it's good to just get the information yourself and really read all of the court dockets. So next we're going to go into Justin Baldoni and Wayfarers' reply. It's going to be a little bit shorter than that one because there's a lot of information that's relayed, but it is very good and it's a good read, and I hope Wayfarer get everything that's coming to them, and it's going to be good. I want these people to pay Stephanie Jones, Leslie Sloan, Ryan Reynolds, Blake Lively, and their representatives. Okay, a little bit of a wardrobe change here because I went to work and came back and we are not done. We are going into now the Wayfarers motion. I am here. If you're still here, it's important to read it for yourself, of course, and understand exactly what we're working with. Here we go. This is the Wayfarers 1. Defendant, Wayfarer Studios, LLC, opposition to plaintiff's motion to dismiss amended counterclaims for Stephanie Jones. Plaintiffs and counter-defendants JonesWorks LLC and Stephanie Jones motions to dismiss Wayfarer Studios LLC amended counterclaims. Improperly argues which are outside the four corners of the amended counterclaim and distorts or simply ignores factual allegations that, if acknowledged, would be fatal to plaintiff's motion. The court should not be misled. As shown below, the amended counterclaim's factual allegations, which accepted as true as they must be under Rule 12b, are more than sufficient to plausibly state Wayfarer's asserted claims for breach of contract, breach of the covenant of good faith and fair dealing, and defamation. The agreement included a confidentiality clause which required JonesWorks to protect the confidential, sensitive, and proprietary information of Wayfarer and related parties and bound JonesWorks to use such information solely in the performance of JonesWorks' services to Wayfarer unless otherwise required by law. During production, Lively hijacked control of the film and precipitated a press uproar that created a significant public relations crisis for Wayfarer in the summer of 2024. Abel continued to work with Wayfarer to address the public relations issues caused by Lively and to negotiate a truce between Wayfarer and Lively, ensuring that neither party would engage in negative press relations aimed at the other. Although Jones had not previously worked on Wayfarer's account for years, she unilaterally inserted herself into the crisis in the summer of 2024, perpetrating to represent Wayfarer's interest. Jones's efforts were not effective as they were not coordinated with Abel and Wayfarer's public relations work, and she often disregarded Wayfarer's express directives and goals. For instance, Jones contacted a Daily Mail reporter concerning a story about Baldoni and Lively, despite having been instructed that Wayfarer and Lively had called a public relations truce. Jones's conduct caused a crisis of its own, leaving Wayfarer to smooth over the reports that a Wayfarer representative, Jones, had been communicating negative information about Lively. When Wayfarer instructed Jones to stop communicating on its behalf, Jones ignored the directive and contacted Sony Entertainment executives. On the same day that Jennifer Abel was walked out of the office, Lively's publicist, Leslie Sloan, called Wayfarer's confidentiality retained crisis management consultant, Melissa Nathan. Sloan told Nathan she should anticipate a lawsuit based on text messages Sloan had seen between Nathan and Abel, stored on Abel's improperly seized cell phone. Wayfarer alleges on information and belief that Jones falsely told Sloan that Wayfarer had orchestrated a malicious smear campaign to destroy Lively's reputation as retaliation for Lively's sexual harassment allegations. Jones knew or should have known from numerous texts and emails that her statements were false, and that by August 2024, Wayfarer was scarcely engaging with the press, much less engaging in a smear campaign against Lively. Wayfarer further alleges on information and belief that on August 21st, 2024, or shortly after seizing Abel's cell phone, the Jones parties transmitted the entirety of Abel's communication, including Wayfarer's confidential and sensitive information, to Sloan, Lively, and Ryan Reynolds, the Lively parties. On September 27, 2024, working hand in glove with the Jones parties, the Lively parties initiated a sham legal proceeding in New York State captioned Van Zandt Inc. versus Doe's 1 through 10. Inclusive. The Van Zandt action, for the sole purpose of obtaining subpoena power to provide legal cover for Jones's disclosure of confidential information to the Lively parties. As a result of the Jones parties' conduct, including without limitation the disclosure of Wayfarer's confidential information in breach of the agreement, Wayfarer has been harmed, including by being falsely cast as an enabler of sexual misconduct and the archetype of a vicious retaliation campaign against the victim of such misconduct. The court's function on a motion to dismiss is not to weigh the evidence that might be presented at a trial, but merely to determine whether the complaint itself is legally sufficient. I thought that was a pretty good line. Wayfarer has started a claim for breach of contract. To make out a claim for breach of contract Under New York law, the complaint must allege facts which show 1. The existence of an agreement, 2. Adequate performance of the contract by plaintiff, and 3. Breach of the contract by defendants, and 4. Damages. Plaintiffs argue that Wayfarer has failed to adequately allege plaintiffs breached the agreement and the Wayfarer suffered damages, and the Wayfarer has not alleged a material breach excusing its own performance. As discussed below, none of these arguments has merit. Wayfarer alleges plaintiffs breached the agreement by 1. Disclosing Wayfarer's confidential and sensitive proprietary information, and 2. Failing to perform its strategic communication services as its role as Wayfarer's public relation representative in a professional manner and in accordance with the goals mutually established by Wayfarer and Jones Works. Plaintiffs claim that the allegations that they breached the agreement are not plausible. Wayfarer's first claim for breach of the confidentiality provision is adequately pleaded. With respect to the first claim for breach of the confidentiality provisions of the agreement, plaintiffs argue that the Wayfarer's amended counterclaims are hopelessly vague, in that they fail to identify what confidential information was disclosed or how the disclosure violated the agreement. This is a mischaracterization. Wayfarer's amended counterclaims set forth a detailed factual narrative describing the nature, method, and recipients of the alleged disclosure. Specifically, and among other things, the amended counterclaims identified confidential communications with Abel, including internal discussions, strategic communication, and sensitive opinions about ongoing public relations crises, which were disclosed to third parties, including the lively parties, and were ultimately used to harm Wayfarer's business and reputation. Further, Wayfarer alleges that the Jones parties confiscated Abel's iPhone on August 21st, 2014. Come on now, Wayfarer, it's 2024, man. Don't make a mistake. Dang, there's a typo. On August 21st, 2024, obtained her passcode under false pretenses and accessed, copied, and monitored her communications, including text messages and emails containing the confidential information stored on her iCloud account, and provided the data to the lively parties. Plaintiffs hang their hat on the claim that the plaintiffs disclosed Wayfarer's confidential information in response to a lawful subpoena in the sham Van Zandt action. Plaintiffs would have this court simply ignore the allegations that the Jones party disclosed confidential information obtained from Abel's seized and improperly accessed phone to the lively parties before any subpoena was issued, and that they disclosed it for a second time after receiving the sham subpoena. In other words, by myopically focusing on the latter issued subpoena, the motion sidesteps Wayfarer's core allegations that the damaging disclosure of confidential information occurred before any subpoena was issued, and that the subpoena was later used as a pretextual and attempt to legitimize the earlier unauthorized disclosure. In short, the amended counterclaims are not, as plaintiffs argues, speculative and conclusory and built on speculation, interference, and generalities. Rather, the pleading identifies the confidential information at issue, how it was obtained, the timing and context of the disclosure, and the specific third parties to whom it was provided. These allegations are not mere labels and conclusions or formalic recitations of the elements of a cause of action, but rather provide a concrete factual basis for the claim as required by federal pleading. Plaintiffs contend that the information stolen from Abel's phone does not qualify as confidential information under the agreement, and the Wayfarer fails to tether any alleged disclosure to the language of the agreement. Yet, the agreement broadly defines confidential information to include confidential, proprietary, and or sensitive information about Wayfarer, its customers, or other related parties. As noted, the amended counterclaim alleged that the information disclosed included internal communications, strategic discussions, and sensitive opinions about Wayfarer's crisis management efforts and public relations strategies, precisely the type of confidential and sensitive information protected by the agreement. What the parties intended in their definition of confidential information and whether any of the data purloined from Abel's phone fits within that definition is an issue of fact which cannot be decided in the context of Rule 12b motion to dismiss. In sum, the motion mischaracterizes the amended counterclaims allegations regarding the contractual forbidden disclosure of confidential information by ignoring the detailed factual narrative, disregarding what is actually alleged in the amended counterclaims, including the sequence of events pleaded therein, misstating the contractual definition and scope of the term confidential information, and treating the amended counterclaims allegations as vague or speculative when they are in fact specific and detailed. It makes sense to me what Stephanie Jones and Leslie Sloan did. The amended counterclaims, when read in their entirety and in light most favorable to Wayfarer, state a plausible claim for breach of contract. The motion's selective and incomplete reading from the amended counterclaims distorts or ignores the nature of what is alleged and should be rejected. Wayfarer's second claim adequately pleads plaintiffs breached the agreement by failing to perform its services in a professional manner. Wayfarer alleges plaintiffs breached the agreement by failing to perform strategic communication services as Wayfarer's public relation representative in a professional manner and in accordance with the goals mutually established by Wayfarer and Jones Works. The amended counterclaim alleged several ways in which this provision of the agreement was breached. Wayfarer alleges that Jones had been in Europe and largely incommunicado, save for the disastrous efforts at self-preservation for weeks during the critical month of August when the film premiered. Wayfarer also alleges that Jones contacted a Daily Mail reporter about a story that had published about Baldoni and Lively in violation of Wayfarer's directive and in blatant disregard of Wayfarer's strategy. Further, Wayfarer alleges that in response to Jones's reckless and unauthorized activities, Wayfarer instructed Jones to cease all activities on behalf of Wayfarer and Baldoni, but Jones insisted that she could do whatever she wants to clear her name, and emailed a number of key Sony executives working on the film, placing blame on her team. These allegations suffice to state a claim for breach of the agreement clause requiring Jones Works to perform its obligations in a professional manner. The clause specifically identified in Wayfarer's second claim for breach of contract. Plaintiffs contend that Wayfarer's second breach of contract claim is only the plaintiff breached the agreement by failing to follow Wayfarer's instructions. They argue that there is no provision requiring plaintiffs to follow their client's instructions and therefore the claim fails. This argument fails for three reasons. First, it ignores all of the allegations of breach in the amended counterclaims discussed above. Second, it oversimplifies Wayfarer's claim with respect to instructions. It is not simply the plaintiffs failed to do as they were told by their client, but they had acted contrary to Wayfarer's interests and goals, thereby breaching the agreement. Finally, plaintiff's argument is premised on the assumption that the phrase in a professional manner and in accordance with the goals mutually established by Wayfarer and Jones Works clearly and unambiguously did not require plaintiffs to follow Wayfarer's instructions. However, is one of the cases plaintiffs rely upon noted, when denying the motion to dismiss the majority of the breach of contract claims, a claim should not be dismissed if there is an arguable claim under the contract, where the language in the contract is reasonably susceptible to more than one interpretation. And then here in the footnotes, I just made it in red because it seemed a little bit interesting at the time. Further, the amended counterclaims allege that Jones Works disclosed confidential information to Lively parties wrongfully and without any legal obligation to do so, then redisclosed that information as part of a scheme to use a sham subpoena to provide retroactive legal cover. On their face, these actions surely violate the agreement's requirement that Jones Works conduct its activities on Wayfarer's behalf in a professional manner and in accordance with Wayfarer's goals. The breach of contract claims adequately plead damages. At the pleading stage, general factual allegations of injury resulting from the defendant's conduct may suffice to state a claim. Then they name all of the other rulings that had kind of that same thing in the court of law. Although plaintiffs characterize Wayfarer's damage as speculative, the amended counterclaims expressly state that as a direct and proximate result of plaintiff's disclosure, Wayfarer suffered reputational and business harm, including public scorn, loss of business opportunities, and damages to its future business prospects, even to the point of casting doubt on Wayfarer's future visibility as a studio. Wayfarer further alleges that it has publicly been falsely cast as an enabler of sexual misconduct and the archetype of a vicious retaliation campaign against a victim of such misconduct, and that its very viability as a studio has been thrown into doubt as a direct result of Jones's action on behalf of Jones Works. The amended counterclaim also alleged a direct causal chain from the theft and disclosure of confidential information to its use by the lively parties and the resulting harm to Wayfarer. These allegations are sufficient at the pleading stage, as damages do not need to be proven with specificity until later in the litigation. In short, the motion severely mischaracterizes the amended counterclaim's factual allegations. Wayfarer's breach of contract claim can be dismissed only if they fail to provide sufficient factual matter to state a claim to relief that is plausible on its face. The amended counterclaims meet and exceed this standard. The Speak Out Act is inapplicable to Wayfarer's breach of commercial service contract claims. Plaintiffs argue that the Wayfarer's first claim for breach of the confidentiality clause is barred by the Speak Out Act, which provides the no non-disclosure clause and non-disparagement clause agreed to before a sexual harassment dispute arises shall be judicial enforceable in instances in which conduct is alleged to have violated federal, tribal, or state law. The Act's stated purpose is to empower survivors to come forward, hold perpetrators accountable for abuse, improve transparency around illegal conduct, enable the pursuit of justice, and make workplaces safer and more productive for everyone. The legislative history of the law, including material cited in the motions, demonstrate that the Speak Out Act is aimed at forced NDAs in employment and consumer contracts, and that it simply clarifies that these clauses cannot be enforced unless the survivor chooses to agree to the clause after the dispute arises. Plaintiffs are unable to provide any authority for the broad expansion of the Speak Out Act to an agreement between business entities to maintain the confidentiality of sensitive business or proprietary information. In other words, that the Speak Out Act is a blanket bar to all confidentiality agreements rather than to agreements between employers and current, former, and prospective employees and independent contractors, and between providers of goods and services and consumers expressly contemplated by the Speak Out Act. Moreover, the applicability of the Speak Out Act to the agreement and to the claims asserted by Wayfarer is a disputed issue of fact, not appropriate for consideration on a motion to dismiss pursuant to Rule 12b. Wayfarer adequately pleaded performance and alternatively excused from performance. Plaintiffs contend that Wayfarer fails to adequately plead that its alleged breach was excused. Preliminary, this argument fails because Wayfarer alleges that it performed its obligations under the contract. Further, this argument wrongly assumes that Wayfarer's purported breach preceded the Joneses party's breaches, thereby excusing the Jones party's performance. The amended counterclaim expressly plead that the conduct asserted as the basis for the allegations of breach, the disclosure of confidential information on or about August 21st, 2024, and the pattern of unprofessional and reckless behavior by Jones occurred before Wayfarer terminated the agreement with Jones Work, effective at the end of August of 2024. Woo, that's juicy. So yeah, that was August 21st that Jones gave Leslie Sloan Abel's text messages, but Wayfarer was still with Jones Works at that time. Performance under a contract is excused when the counterparty to the contract first materially breaches its own obligations under the contract. When a party has breached a contract, that breach may excuse the non-breaching party from further performance if the breach is material. To the extent that the motion alleges that Jones Works' own breach of the agreement did not excuse Wayfarer's later termination of the agreement, that is relevant to the question of whether Wayfarer can assert a claim for the Jones party's breach of the agreement prior to any purported breach of Wayfarer. As set forth above, Wayfarer has set forth factual allegations sufficient to establish that the Jones parties breached their obligations under the agreement well before Wayfarer decided to terminate the agreement. At the time that the Jones parties breached the agreement, first by failing to perform its services in a professional manner consistent with Wayfarer's goals, and then by disclosing confidential information, Wayfarer had undertaken no action that even plaintiffs can claim to have constituted a breach. Wayfarer has stated a claim for breach of the implied covenant of good faith and fair dealing. Plaintiffs next argue that Wayfarer's claim for breach of the implied covenant of good faith and fair dealing, the implied covenant, should be dismissed as duplicative. This argument fails because 1. Wayfarer has pled this claim in the alternative to its breach of contract claim, and 2. Plaintiffs dispute whether the contract requires them to follow their client's instructions and stated goals. First, courts in this circus have recognized that while a plaintiff cannot ultimately recover on both a breach of contract and breach of implied covenant claim, it may litigate both claims through discovery when the claims are pled in the alternative. A claim for breach of contract does not preclude a party from bringing a claim for breach of the implied covenant of good faith and fair dealing when they are brought in the alternative. A party is only precluded from recovering on both theories at the same time. Wayfarer pleads its implied covenant claim in the alternative. Second, this principle is even more apt because plaintiffs dispute the existence of contract terms because prematurely dismissing an implied covenant claim could potentially leave the plaintiff without any remedy. A claim for breach of the implied covenant of good faith and fair dealing may be brought in the alternative to a claim for breach of contract, where there is a dispute over the existence, scope, or enforceability of the putative contract. Plaintiffs dispute Wayfarer's assertions about the terms of the contract. Thus, Wayfarer's alternative claim for a breach of the covenant of good faith and fair dealing should not be dismissed at this stage of the proceedings. Wayfarer's defamation claim is adequately pleaded. Plaintiffs' argument that Wayfarer failed to plead a claim for defamation is premised on the false assumption that the allegations are limited to 2 words, smear campaign. However, the amended counterclaim alleged that the Jones parties made statements to others to the effect that Wayfarer had retaliated against Lively and others for reporting alleged sexual misconduct, including orchestrating a smear campaign by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. California law applies to Wayfarer's defamation claim. Plaintiffs assume that New York law applies to Wayfarer's defamation claim. Although the argument contains a New York choice of law provision, the language of that provision is narrow and limited to the agreement itself. The question then is whether the provision is valid and whether its scope extends to all of Wayfarer's counterclaims. A federal court sitting in diversity applies the choice of law rules to the forum state to determine the validity and scope of a choice of law provision. Under New York law, a choice of law provision is enforceable if the chosen law has sufficient contacts with the transaction and there is no fraud or violation of public policy. Although Wayfarer is based in California and performs its overwhelming majority of its work in California, the choice of law provision is likely valid and enforceable under the prevailing law. However, under New York law, a contractual choice of law provision is applicable only to cause of action sounding its contract unless the express language of the choice of law provision is sufficiently broad as to encompass the entire relationship between the contracting parties. According, the choice of law provision only requires the court to apply New York law to contractual claims. Because the New York choice of law provision does not apply to Wayfarer's defamation claim, the court must engage in a choice of law analysis to determine what state's substantive law applies to the claims. The first step is to determine whether the laws of New York and California conflict. Here, there exists substantive conflicts between the laws of New York and California as to Wayfarer's defamation claims against the Jones parties. For example, with respect to defamation, California extends no greater protection to opinions than does the United States Constitution, while New York law, by contrast, in excess of the United States Constitution, provides for absolute protection of opinions. Because there is a substantive conflict between the laws of New York and California as to Wayfarer's defamation claims, the court must analyze whether to apply New York or California law. As the laws of New York and California conflict, the court must determine which law to apply to the defamation claim. California has a significant interest because Wayfarer has its principal place of business in California. Wayfarer suffered injury to its reputation in California, and Wayfarer's economic losses were felt in California. Moreover, as a participant in Hollywood's entertainment industry, the beating heart of which is indisputably the state of California, Wayfarer's reputation mattered most in California. Wayfarer adequately pleads a defamation claim under California or New York law. So after going through all of that, they're like, you know what? Even if it is New York law, guess what? It still works, okay? So under either California or New York law, the assertion that Wayfarer retaliated against Lively for reporting sexual misconduct is not a statement of opinion, but one of fact. Under California law, to constitute defamation, the offensive publication must consist of statements of fact, not opinion. A statement is defamatory only if it's capable of being proved true or false. But expressions of opinion often imply assertions of fact and are therefore actionable. Thus, a statement in the form of an opinion may be actionable if it is implied that it is based on some undisclosed defamatory facts. The issue of whether the statement is fact or opinion is one for the jury. The jury, okay? Question is whether a reasonable fact finder could conclude the published statements imply a provably false assertion of fact. To answer that question, the court applies a totality of the circumstances test and reviews the language of the statement and context in which the statement was made. To determine whether a statement is an assertion of fact or opinion, courts applying New York law generally consider 1. Whether the specific language in issue has a precise meaning which is readily understood. 2. Whether the statements are capable of being proven true. And 3. Whether the full context of the communication in which the statement appears is such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact. Context includes not only the immediate context in which the disputed words appear, but also the larger context in which the statements were published. That's interesting, that the context is not only the immediate words, but also the larger context in which the statements were published. If a statement contains opinion, the court must then examine whether the statement is pure opinion and thus not actionable, or mixed opinion and therefore actionable. The actionable element of a mixed opinion is the implication that the speaker knows certain facts unknown to his audience which support his opinion and are detrimental to the person about whom he is speaking. Regardless of which state's law govern plaintiffs' attempt to recast their statements as opinion fails. These statements were susceptible to a defamatory meaning, namely that Wayfarer had permitted egregious sexual offenses and then retaliated against their purported victim. Those are statements that are capable of being proven true or false and that are readily understood as having a derogatory meaning about the target of the statement. Even with regard to the specific phrase smear campaign, given that Jones was for a time under contract with Wayfarer, the clear implication of statements about Wayfarer's purported campaign of retaliation against Lively is that Jones Works knew of information that would give rise to the purported opinion that Wayfarer had in fact alleged in an illegal smear campaign against Lively. The amended counterclaims allege that the Jones party made statements about Wayfarer that were intended to and did convey false and deprecatory assertions in fact against Wayfarer, and the motion's willful misreading of the amended counterclaims is to no avail. The motion also asserts that Wayfarer fails to allege that the Jones party made a false statement, but the amended counterclaim expressly states the statements made by Jones and Jones' works about Wayfarer were false. The motion suggests that Wayfarer must do more, seeming to fault Wayfarer for failing to prove a negative. That's just so funny. Like, girl, they told you the statements weren't true. What you said was a lie. They weren't true. And you're saying, you need to do more. Like, well, how are we supposed to do that? You know, you're seeming to fault Wayfarer for failing to prove a negative. That's a funny sentence. But Wayfarer has alleged that the statement that is engaged in a retaliatory smear campaign against Lively were false, in that not only was Jones well aware that Lively had not actually been sexually harassed on set, she also knew that there had not been a smear campaign. The amended counterclaims continued Wayfarer had scarcely engaging with the press at all in August of 2024, much less carrying out offensive tactics in retaliation for something that never happened. There is no basis for the motion statement that the amended counterclaims fail to allege facts sufficient to establish that the defamatory statements attributed to the plaintiffs were actually false. Finally, Wayfarer alleges adequately that plaintiffs acted with actual malice, assuming arguendo that Wayfarer is in fact a public figure. The amended counterclaims express allegations support actual malice. With respect to the statement that Wayfarer engaged in a malicious smear campaign to retaliate against Lively for reporting sexual harassment, the amended counterclaims allege that Jones knew this was false, as not only was she well aware that Lively had not actually been sexually harassed on set, she also knew that there had not been a smear campaign. This is clear because Jones was copied on many of Wayfarer's emails and text threads during the relevant period and knew full well that Wayfarer was scarcely engaging with the press, if at all, in August of 2024, much less carrying out offensive tactics in retaliation for something that never happened. In other words, the amended counterclaims alleged both that Jones, and therefore Jones' works, knew that the assertion that Wayfarer deliberately smeared Lively in retaliation for reporting sexual harassment was false, and that she was copied on communications that would have caused her inevitably to believe that the assertion was false. Yet the Jones parties made the assertions anyway. That constitutes the requisite knowledge of falsity for asserting actual malice in the context of defamation. Notably, the motion falsely states that the amended counterclaims are devoid of any allegations that Jones possessed information, ignored known facts, or otherwise acted with the requisite subject awareness of falsity or probably falsity. Once again, the motion flatly ignores the actual allegations of the amended counterclaims and argues for dismissal based on untrue statements about what is alleged. Plaintiffs are not entitled to recover attorney fees. Yeah, no freaking way. Stephanie Jones, are you going to get your freaking attorney fees? Ew, you started this. You, Leslie Sloan, and Blake Lively started this whole thing. Plaintiffs argue that they are entitled to attorney fees under New York's state anti-SLAPP law. As an initial matter, the request for attorney fees is barred by plaintiffs' failure to request such an award in their notice for motion. Moreover, for all the reasons set forth above, the motion should be denied entirely, and therefore there cannot be no entitlement to attorney fees. Even if the court were inclined to grant the motion, the majority of courts in the Southern District of New York rightly hold that the law does not apply to claims such as these. The Second Circuit has not yet directly addressed the question of whether New York's anti-SLAPP law applies in federal court. Still, federal district courts in the Second Circuit, including courts in this district, overwhelmingly agree that the holding of La Libert versus Reed precludes the application in federal court of New York's anti-SLAPP law, which creates a special procedural mechanism through which defendants can invoke the anti-SLAPP law in a motion to dismiss. Furthermore, under Rule 11, sanctions are permissive, while under the anti-SLAPP provision, sanctions are mandatory. Notably, the standard for avoiding permissive sanctions under Rule 11, requiring only a non-frivolous claim, which we all know about now because, Blake Lively and Ryan filed Rule 11 sanctions for frivolous claims against them, which is so crazy, is lower than the standard for imposing a mandatory award of attorney fees under Section 11. So notably, the standard for avoiding permissive sanctions under Rule 11 requiring only a non-frivolous claim is lower than the standard for imposing a mandatory award for attorney fees under Section 70.8. In effect, the Jones parties asked the court to create a rule that would automatically sanction any plaintiffs whose non-frivolous defamation claims failed on Rule 12b motion, a mandatory sanction entirely inconsistent with Rule 11. Then they go into a law that Stephanie Jones put into a motion, and they're just saying, with this one, for example, there the court found that the defendant's entitlement to an award or of attorney fees under the New York anti-SLAPP law is substantive and not procedural, and therefore held that applying the state law in federal court would, in that respect, be consistent with La Liberté. Importantly, however, Judge Oetken's ruling acknowledges that his decision in Bobulinski conflicts with the decision of other judges in the Southern District, New York, that have been found that the New York anti-SLAPP law's fee-shifting provision does not apply in federal court, including this court's holding in Brady Bobulinski's conclusion. For the foregoing reasons, Wayfarer respectfully requests that the court enter an order denying the plaintiff's motions in its entirety. Oh gosh, I'm getting so tired. For the foregoing reasons, Wayfarer respectfully requests that the court enter an order denying plaintiff's motions in its entirety. In the event that the court finds any aspects of the pleading defective, Wayfarer respectfully requests that the courts grant leave to amend. Okay, y'all, so there you have it. Those are the two. Thanks for sticking it out with me. My gosh, that was a lot. But there it is. That's everything that's filed. Nothing else has been filed today, and it's a long weekend, okay? So that was everything. I thought it was pretty good. I think they came back onto Stephanie Jones one by one. I mean, yeah, her claims were a little bonkers. I mean, when I was reading them, I just remember thinking, dang. She was just it was pretty crazy, but we'll see what this judge comes up with and see what happens here. Now, without any further ado, let's get to some of your comments from the last couple of days. These are in no particular order at all, just some screenshots I take at comments that kind of stick out to me or stand out to me that I just want to talk about. I keep them in my camera roll, and then when I do a video, I kind of just post them. So sometimes I don't remember what the comments are. Honestly, I'll be really honest with you. But here's one of them, and this is from Jan 0626. My dad would have done the same thing. Taylor's entire hard-working life is at stake, and her dad knows what she could be hurt both professionally and emotionally by this bully. I doubt Taylor had ill intent for Justin, but was used by her best friend without her permission or involvement. If my best friend was up to no good, I would cut ties immediately and tell someone I trust, like my mom, dad, and lawyer, what was going on. You are right on, Mandy. Blake and Ryan need help, especially for their children's sake. Then Joanne Vermont 8372 says, this is actually scarier than the theory that Blake Lively fell for Justin Baldoni and was rejected. At least that would be a reason people could get around. This random evisceration of someone for no concrete reason is truly terrifying. And then Margaret replied back saying same thing that she did to Penn Badgley. And I absolutely agree to you ladies. It is frightening that someone could just not like someone or just think that they're weak and just creepy and then just ruin their lives. At least if there was a reason behind it, some plausible reason, it would make a little bit more sense. But yeah, she did confirm by her own admission. This is not a lie. We don't have to tell lies around here. By Blake's own admission, she admitted that when Penn Badgley got on Gossip Girl, she didn't like him and she tried to turn the entire cast on him. And then when that failed, she dated him. Come on. Francesca8331 says, my theory, they wanted to take over the movie and get Blake production credit, as possibly get a hold of the entire franchise. I don't think Blake was in love with Justin. She may have been attracted to him, though. That might have been made Ryan jealous. Justin made it clear he was not interested in Blake. When she flirted, he never flirted back. He would bring up his family. Girl, you're like, are you in my brain? Because I've said this so many times. And when I go through all of the texts of Blake, she was being so sexual, so flirty, so, and then Justin would always bring it back to his family. So I also don't know if she was attracted to him. I think she likes more knucklehead, kind of brash men. And Justin is, he's a teddy bear. He's a little sweet guy. I mean, yeah, he's super duper attractive, obviously, but I also don't know if this was about an attraction level. I think Blake Lively often always gets what she wants by playing that kind of role when it comes to men and luring them in, and they all fall for it. And I think Justin just wasn't falling for it, and that got Blake mad. Kimberly Lawrence 6693 says, you're awesome and adorable. Thanks for being a top team captain for Team Baldoni, expressing all that we are thinking and feeling about this crazy mess and helping us all continue to be a voice for Justin. Thank you. I know why I screenshotted that, because, sometimes you get so much negative that you just need some positives, and focus on the love, focus on the positive. Thank you for calling me a top team captain. That means a lot. I really feel like this is kind of a mission for me, is to really bring this darkness and shine light onto it and, fight for what's right here. And yeah, I'm so grateful, and I'm honored to be here, and I'm honored that you guys are all like here with me, like totally grateful. Honestly, I'm just, every day I'm like, whoa, this is so crazy. Perfume Therapy said, oh my God, I love the ABH lip gloss. Do we have the same color? Mine is butterscotch, smells like vanilla ice cream. I remember when I read this and I was like, butterscotch, vanilla ice cream. Mine definitely isn't that. Mine is like the peach nude. But y'all get my hands on some butterscotch lip gloss. My gosh, thank you for sharing that. I didn't even know that existed, and I hope that I can get it one day. The Real Tom Brocott says, yeah, nah, I don't think Blake tried to blackmail Taylor. I think that she did ask Taylor to delete texts and maybe said something to the effect of, we're in for a penny, not in for a pound. But this dirt being leaked by Taylor, of course, is just a 4D chess move to distance Taylor from Blake's mess. Now Taylor is a good guy and victim. She's really good at pretending to be a victim. Why would Blake even threaten to release text that's mutually assured destruction? She's instantly outed as the person who leaked them and also being part of any embarrassing convos. This didn't happen. LOL. Taylor's team has once again fooled everyone into thinking she's the victim. I remember when I read this and I thought, what an interesting place to come from. And also I partly agree. And this is why I love that people have different opinions and thoughts and are thinking for themselves. And a lot of people know a lot more about the Swifties than I do, for example, or Blake Lively than I do. I've already admitted that I didn't know much about Ryan or Blake before all of this went down. So I was Justin Baldoni fan since Jane the Virgin season 1, a long time ago. Do you know what I mean? I didn't know anything about anyone else. Honestly, any celebrities, anything in Hollywood, nothing. I never followed anything. Like, this is a really new and weird space for me to be in, because I'm uncovering so much that I had no idea what's going on in Hollywood. So I do think there is a part of me that agrees, because how quickly the narrative turned from Blake Lively and Taylor Swift being like mean girls, like Taylor being a mean girl and being with Blake and to now being like the victim of Blake. So there is a part of me that thinks that some of this is PR, and there's a part of me that thinks that she probably did make a deal with the Wayfarer parties, Taylor Swift, to say, hey, look, I'll give you everything you need, but just don't depose me in the future. Or, I mean, I'm sure the lawyers worked something out so that Taylor can now, take the high ground and get out of this. So I'm I'm with you in a little bit, but I also not in the way I do think Blake Lively probably put out a statement of support for me, because a statement of support, even today, if Taylor came out and was like, Wayfarer's lying, this never happened, it would change everything. If Taylor would have come out anytime between December to now and said that she's, sticking and staying with her best friend, et cetera, et cetera, et cetera, I mean, it would change everything, but she hasn't. So I think something definitely did go down between those girls. Like, something in me just knows there's a rift, and I think it was because Taylor wouldn't support Blake, because Taylor knew that Blake intentionally sought to ruin these people's lives and hijack the movie. And Kala 217, I'm so sorry, says unjustly harassed. How about just harassed at all? Yeah, so in the statement that the Lively parties put out, this whole gaslighting statement, like, we are so happy because she was being unjustly harassed by being subpoenaed, and they were talking about Taylor Swift, and it's like, unjustly harassed? I don't think she was being harassed at all. They followed legal procedure to send a subpoena to her lawyers to get communications that they had on information and belief that existed. That's not harassment. That's actually like literally what they're supposed to do as lawyers. So let's just, mind our words there, Blake Lively's team. You know what I'm saying? And that's the episode today. That's the show. Okay, whoa, I don't know what I'm doing. That was weird. But anyway, that's the episode today. I hope you're having the most amazing Friday. I know I usually leave everyone here with a little je ne sais quoi, little motivation, inspiration. But really, I just want you to have a good weekend. I want you to take time for you. I want you to have a good time. I want you to do something. I want you to love yourself a little bit more. And yeah, just try to have fun and relax and do whatever your heart is telling you to do, Have a good time. Dance a little bit. Make some love. Kiss somebody. Do something. As long as it's consensual. Obviously. But yeah, I just want you to have a good time. And if you are in the States, in the Americas, and it's your long weekend, have the best time. We just had ours last weekend. And have a good time. Tomorrow I'm going on a road trip with my bestie. I'm so psyched. Bright and early. And yeah, I wish nothing but pure happiness and joy and peace for you this weekend. So I hope you're able to find even just a little piece of peace that you can treasure and hold on to. I will see you next week. Enjoy your weekend. It's always, always a pleasure to be here. Let's keep focusing on love and light and lifting each other up and not tearing each other down, because we are building a community here of truth setters and light seekers. And yeah, thank you so much. Have the best weekend. Love you. Talk to you soon. Bye.